during the hearing, in which case there will be a brief adjournment for that purpose. Yes, Mr. Lowe.
Ladies, I appear for Fenris. The Court of Appeal judgment is in your key documents file at tab 3. The order is at tab 4. The judgment of Mr. Justice Macmillan, the Grand Court, is tab 1 of the key bundle, and his order, I think, is at tab 6. There are two questions in this appeal. The first was, it deals with the loss period. Was the Court of Appeal correct in holding that we can't recover any losses once judgment has been given? That breaks the chain of causation. The injunction was granted on the 27th of February 2009. It's in bundle 3. The reference to it is it's at that tab.
Mr. Lowe, can I interrupt you for a moment? I'm
Yes.
fairly sure that all members of the board are using electronic bundles, and therefore it would be helpful and sufficient for us to be given electronic page numbers rather than bundle numbers, tab numbers, or internal bundle numbers.
I'm sorry, I apologize.
That's quite all right.
May I start again then? The Court of Appeal judgment you will find at page 187. The judgment of Macmillan, J, you will find at page 4. The Court of Appeal order is at page 232, and the Grand Court order is at page 184. As I said, the first question in the appeal that concerns the period over which loss runs, and the starting point, but not necessarily in causative terms, but the starting point would be the order that was made by Mr. Justice Quinn on the 27th of February, which you'll find at page 738. I'll come to that in a moment. The Court of Appeal in the original action gave its judgment, Mr. Justice Foster gave his judgment in the original action on the 16th of February 2012. You will find his order at page 749. That is the loss period the Court of Appeal held to apply. In other words, 3 years. What the judge accepted was that the period ran until payment, which wasn't until the Privy Council had rejected the appeal in the main action on the 4th of May 2016. The payment was made on the 25th of May, and the reference to that is at page 379, paragraph 15. And we say that we were never in the position in a counterfactual inquiry where we wouldn't have been able to keep a profitable portfolio until the conclusion of the case. The judgment wouldn't have stopped us doing that if you examine the counterfactual scenario. The second issue on the appeal is whether the Court of Appeal strayed impermissibly beyond causation into quantification. The dividing line here is important because there was no appeal to the Court of Appeal on quantification. The judge conducted an inquiry. He didn't give a lot of reasons, but there was no appeal against that, and the Court of Appeal didn't deal with it in the evidence. It discarded, we say, the ordinary rule as to where that dividing line runs, and our submission is it shouldn't have done so. Before I address these points, and I was going to address the second point first because it sort of sets the scene, there are just one or two preliminary remarks I'd like to make very quickly. Something went horribly wrong with the inquiry. It had originally been listed for 4 days. If you have a look at page 4, you can see on the electronic bundle, you can see exactly what hearing dates happened. It transpired that those 4 days weren't enough, and another 4 days were needed. And it transpired that those weren't enough, and we needed another 4 days. And in all, we had 12 days, which we'd exceeded the time estimate twice. And that was in circumstances where we had a single expert and only 2 factual witnesses. The judge was, at the end of that process, plainly irritated and perhaps overwhelmed. The Court of Appeal, as you'll have seen from their judgment, were taken aback with certain remarks by the judge, which may have reflected his impatience, but also, as you can see, reflected theirs. He did, however, we say, get the dividing line between causation and quantum right. He got that. That was correct, what he said, and I'll show you that in a moment. But in the Court of Appeal, the pendulum swung rather too far the other way. And in seeking to correct the findings, the Court of Appeal appears to have thrown out the conventional analysis at a point where they should have really adopted the orthodox dividing line between quantification and causation and not embarked on quantification. The fact that the trial went off the rails in a sense was not the parties, well, it was, of course, it's the party's fault, but not anyone more than the other. And neither side was to blame for the somewhat intemperate remarks that the judge made. And so the Court of Appeal felt that they had to do something and put it right. And I think that's not really in dispute. So with that, I was going to look at the dividing line between causation and quantification, and start with what should have happened, what would have happened in an orthodox world, and then show you what happened in the case. Fenris's case was that.
Can I just pause you, Mr. Lowe? When you say we accept that the Court of Appeal needed to deal with the consequences of the judge's intemperate remarks, do you mean by rehearing the rehearing the inquiry, or in what other way do you accept that the Court of Appeal needed to deal with them?
It revisited the question of causation. It needed to do that because the appeal was confined to causation. And what it did is it set aside the judge's findings on causation and substituted its own. But it went further than that. It also quantified the loss. And that's where we say it should not have gone that far, because that was an area that wasn't appealed. And I need to show you how that worked out in the judgment. But at any rate, the Court of Appeal set aside the judge's findings on causation because they said essentially that he hadn't approached those judicially properly, hadn't considered the submissions properly, and some of his remarks had been intemperate and put the burden too far on the other side. So they were entitled, we knew that they were entitled to set aside the finding on causation. They then decided, rightly we say, that issue themselves, and then embarked on a quantification exercise, which we say they shouldn't have done. I hope that answers my Lord's question.
Yeah, thank you.
So our case, of course, was that we would have had the order not been made in the counterfactual world, we would have had a portfolio of actively managed securities, European securities, small caps. And obviously, that is a counterfactual scenario that we say would have run over a number of years, whatever the loss period is. A hypothetical portfolio is, of course, almost impossible to devise. You're not going to be able to have that crystal ball, and it's unreasonable to pretend you do in a hypothetical counterfactual inquiry, because over time, what can you guess that the fund manager would put there? No one in 2009 would have had such a detailed crystal ball. And we submit it would have been...
Mr. Lowe, Lord Stevens has his hand up.
Oh, I'm so sorry.
Well, bring you back some time. Did you object at the time to the Court of Appeal embarking on quantification?
Yes. I mean, the problem was I told them to adopt the quantification the judge had. It hadn't been appealed. And then they said they had to do something, and we then debated what they could do. But I'll come to what happened in the Court of Appeal. You'll see from the submissions they cite that I made the submission that we'd suffered some loss, and therefore, and they didn't adopt that submission, and then they went on to deal with the quantum, but they didn't do. And we discussed it, and then of course we see what they did in their judgment. They adopted Ennismore's quantification from the inquiry.
I'm sorry, I don't understand. Did you ask them not to quantify the damages?
Well, I said it wasn't appealed, it wasn't appropriate for them to alter it. When they then said they would, I had a fallback. But it wasn't my primary position all along, was that causation, they shouldn't upset causation. They did upset causation. I had other reasons why they shouldn't upset causation. Then I had reasons why they should find causation nevertheless. And it was clear, and it's clear in our submissions, our written submissions, that we didn't think quantum had been appealed. So if they got to the position where they found some loss, my argument was all along that they should then use the judge's quantification. When they balked at that, I then had to scrabble around to find an alternative, but it wasn't anywhere in the argument. There was no, you'll see, there was no attempt in the written arguments to come up with an alternative quantum. It was, you know, this arose because they insisted that that's what had to be done. Now, the client was, of course, in the position where the Court of Appeal set aside everything. Then, you know, either they would have had to go back to the judge for further quantification, or the Court of Appeal would have had to see where they were. But since quantification hadn't been appealed, and I'll show you that, they should not have gone that far, is our submission.
So though, I think I understand you to mean by causation that the causation analysis is satisfied the moment you conclude that the claimant would have suffered some loss, and that everything else is a matter of quantification.
Yes, my lord. Yes.
So that if two causation cases were pleaded of a completely different type, and the judge found that type A was proved, and the Court of Appeal found that type B was proved, on your submission, if quantum wasn't raised as an appeal item, the Court of Appeal could perfectly rightly find that type B causation route was proved, but still be bound to apply the type A quantification of the type A route. Yes,
although when you look at it, you'll see that the type A and type B were not really any different. It's actually complete. It's a complete red herring, because what the Court of Appeal then said is that we don't accept the judge approached the whole exercise of what causation had to be proved correctly, type A, type B. They say it's type B, but when you look at what they mean by type B, it's type A. It's not different from type A. I'll show you that when I get to it, if you don't mind. If you, I mean, I know this is to many of your lordships very familiar, but if you started off with Allied Maples, which is in and which is at page 1073, the classic passage which is always adopted is at 1008, 1081. It deals with the distinction between loss of a chance when it's dependent on a third party and when it's your own. And then in the passage at page 1081 between letter D and D, B and D, Lord Justice Stuart Smith says questions of quantification may depend upon future uncertain events, whether and to what extent someone will suffer osteoarthritis. It's trite law that these questions are not decided on a balance of probability, but are questions of quantification. So there were two exercises to be done in the normal case. You find that there's some loss, that's a balance of probability, and then you deal with questions of quantification, and you might take into account all sorts of chances, but that's a matter of evaluation, and that's a matter for the judge, and it's not to be dealt with on a balance of probabilities. Of course, the parties are going to have theories about how quantification should happen. They might even plead those. But quantification fundamentally is a matter that isn't done on the balance of probability. The case that deals with quantification, the Supreme Court case that dealt with it most recently, is One Step. It's at page 1451 of the bundle, and the relevant passages were cited by the judge, but you can see them at page 1464 to 65. A case that actually is quite close to the present is Parabola Investments, which starts at page 1523. And you'll see from the headnote that this case involved, it was a case of deceit. And what had happened is that because of the deceit, the plaintiff was unable to trade profitably in the market for stocks. And of course, you couldn't know what kind of stocks you would have invested in over the hypothetical period. And in the headnote, if you read between letter E and G, you'll see the type of claim that was made. The passages from this Court of Appeal judgment are referred to in a number of the others, but it's worth, if you don't mind, if I show you page 1531, where submissions are made about why there shouldn't be any quantum, and you can see Lord Justice Toulson's response to that. Mr. Malik attacked the judge's award of loss of profits on the grounds the case that a specific amount of profits would have been earned at that stage was unproven. Accordingly, only interest should have been awarded. Paragraph 21, his attack on the judge's award for lost profits was similarly submitted that Gill gave no adequate explanation how he invested a larger trading fund. And then you can see roughly what's said, because obviously if you're looking at a trading fund or a business, you aren't in a sense depending on chances of things that you can't control. That's not dissimilar in a way to Allied Maples, but the Court of Appeal then deals with that at page 1532. And the paragraphs that you should look at are 22 to 23 and 24. Those are the passages that are always read out. They're the ones that show that quantification is a different matter. Paragraph 24, Appellant's submission, for example, that the case of a specific amount of profits would have been earned in stage one was unproven, is therefore misdirect. True, the nature of things, the judge could not find as a fact amount of the lost profits at stage one was more likely than not. The judge had to make a reasonable assessment. Different judges might come to different conclusions, and so on. So what is said is that the exercise of working out the profits from a hypothetical portfolio of shares traded was going to be a matter of quantification. The mechanics of the loss, the composition of the portfolio, all of that was a matter for the judge in quantification. Certain of those points were emphasized in the Vassiliou and Hadji Georgiou case, which is, I'm just going to show you very briefly, which is at is at page 1819, decision of the Court of Appeal. Lord Justice Patton gave the judgment. He adopts much of what's said there. In fact, he adopts it. At page 1823, he deals with loss of a chance at the bottom in paragraph 21. He then says at paragraph 25, where the quantification of loss depends upon an assessment of events which didn't happen, the judge is left to assess the chances of alternative scenarios. That's nothing to do with loss of a chance as such, simply the judge making a realistic and reasoned assessment of a variety of circumstances in order to determine what the level of loss has been. To that end, he cites Parabola, and then he deals in page 1826. He says that the judge reached a view about the prospects of success of the restaurant. As Lord Justice Toulson makes clear, that process is not the kind of exercise contemplated at the second stage in Allied Maples, doesn't require a discount to be given. And then he quotes the decision of Sir Anthony Clarke in the Owners of Front Ace, and it's just worth reading what is said there. If I invite you to do that, it's paragraph 27.
Or what do you get out of the quoted paragraph for the relevance, for the purposes of this case?
Simply that the distinction between the distinction between quantification and causation, and that's repeatedly dealt with. And there is, of course, is
this paragraph really about that distinction? It may be an illustration of an aspect of quantification, but was there some submission that it was critical whether this was a causation or a quantification matter which he's addressing?
Well, it's critical. It's critical in a case because you've got to prove causation on a balance of probability, but not quantification. And I think that was the issue. Yes, I'm sorry, Melania.
But suppose the Court of Appeal, having set aside the judge's decision, found that they wouldn't have invested the money. Fenris wouldn't have invested it. They'd have left it in an interest-bearing bank account, which was making 1% per year, say. Now, that is loss caused. They've lost that interest. Assume for the moment that that's loss. But do you say that if they had found that, they would still have been bound to apply the judge's quantification of loss arising from investment in sort of risky equities?
Well, that when you have that degree of difference, that would really be contrary to common sense, Melania. I think I couldn't say that. But that's not what happened. It's not that degree of difference. If you look at the final case, it's perhaps best to look at the judgment of Mr. Justice Newgee. It's Wellesley. It's 1834, and the relevant passages at 1893 to 1895. It's quite long. He starts off by saying at 1893 that despite Allied Maples having been around so long, are still causing difficulty. He says at 1894, subparagraph 4, there are other cases where the claimant doesn't seek to establish as a matter of causation that he has lost the opportunity of acquiring a specific benefit, which is dependent on the actions of third party. Rather, he claims he's lost the opportunity to trade generally. And then he puts Parabola and Vasilia in that category. He then says there's some difficulty in knowing whether the courts are dealing with that as a question of causation or quantification. He points out that Lord Justice Toulson and Parabola suggested that at least trading profitably is part of the question of causation. And he thinks, and then he says on page 1895, if the court finds that trading would have been profitable, then makes the best attempt at to quantify the profits. The Court of Appeal didn't disagree with the statement of principle, and you'll find what they said at page 1986 and 1991. I'm not going to take you to it because it doesn't take the analysis very much further. What it does say is that in the context of quantification, the judges are obviously also involved in evaluating chances. They just speculate on the balance of probability. So if you look at the case in terms of what should have happened, we define our loss, whatever it is, and the court then has to work out whether we've proved some loss of that kind. Quite how specific, we can come to that in a moment. And then the issue of quantification starts. The judge was clearly alive to this exercise. If I give you, I'm going to refer to the unreported version, because the small print on the reported version is quite hard to read. If you go to page 28 of the electronic file, you see he refers to Allied Maples. At page 31, he refers to one-step support on how you deal with quantification. He's also referred to parabola. He refers to SCF tankers and Privalov, the Fiona Trust case. He then expresses the test. If you go to page 32 at paragraph 76, seems to be nothing unexceptional about that. He refers to the submission of Fenris on this point at page 33. And then at page, at page 76, he endorses essentially that same proposition. Over to 77. He makes the point that the boundary between these issues isn't always clear. And then at page 94, he deals with Ennismore's submission at paragraphs 257 and in paragraph 258. He again expresses the view about the dividing line. So in terms of the legal propositions that the judge, there's nothing exceptional about what the judge said, and he was clearly alive to the distinction. We then get to the Court of Appeal, which disagrees with those parts of his judgment. At page, I think you can start perhaps at page 218, you'll see that we made the submission at paragraph 95 that we'd made below. This is part of the Court of Appeal reciting our submissions. The Court of Appeal then, at paragraph 114, says, I accept Ennismore's submission. A passage in the judgment showed the judge misunderstood some of the authorities applicable to the assessment of damages. At times proceeded on the erroneous basis of Fenris proved on the balance of probability it suffered some loss that was not minor or nominal. The court should assess the damage as best it could. Now, pausing there, and that's not wrong, because whatever loss the judge found proved on causation, that was then where he should draw the line. And whatever loss the Court of Appeal found, whatever form of causation it found, that's where it should have drawn the line. The line doesn't change. It's just that the type of causation might be different. But to criticize the judge for making that point, we say was incorrect. And then if you go to, if you look at paragraph, you see at paragraph 129, 3, they make the same point, that the judge was wrong on these aspects, which actually are quite, paragraph 1, 2, 3, these are really quite orthodox ways of describing the difference between causation and quantification. And the explanation they give for doing this is at paragraph 117 and 124. And it's the point that your lords and ladies, my lords and ladies, were really putting to me. You know, what happens if the judge the Court of Appeal found a completely different loss proved? The problem with what the judge said is that Fenris was not claiming a generic investment loss, but the lost profit that it pleaded would have resulted from Vigeland investing the frozen funds in European small caps. And the fact is that that's not anything different to what the judge thought.
Well, with respect, I thought the issue between the parties was not would he or wouldn't he have invested in small caps, but would he or would he invested in small caps in the way he had invested in small caps while acting for Ennismore prior to the crash, i.e. at a very specific and particular pattern of investment in small caps, which it was alleged produced what to most humble investors seems an astonishing rate of return. Well,
the judge didn't find that. The judge came up with his own quantum, because what happens when and you'll see this when I show you the pleading, is that the pleading is that he would have invested in much the same way, and it doesn't then give any detail. That what happens is in the witness statement, he's obviously going to say not just what I would have done but for the injunction, but then try and quantify it. So a witness isn't going to say, well, I suffered some loss and leave it to you, judge. The witness is going to say, well, I suffered this kind of loss and this is what the loss would have been, which is what he did. But in the pleading, he said he would have invested in what he defined as small caps, which actually shares up to 2 billion European. And he then that's what he says. And of course, when the Court of Appeal deals with it, it's very odd, you'll see in a moment, the portfolio they put together for him involves European small caps. It doesn't involve anything else. And it's, when you see what they did, they actually find that he would have invested, or you know, what the mix is in a portfolio between cash and leverage, your cushion, and you know, some treasuries. That's all a matter of quantum. But the actual securities they're looking at are tracking the OSEX, which is a Scandinavian index, and the HSB European, whatever it is, because that's what Ennismore suggested he would do. They're just conservative indices. But you know, when you ask yourself if this is fundamentally different to what the judge was looking at in terms of causation, absolutely not. Can I just show you this and just very quickly show you the passages, because when you see what the Court of Appeal did, it's not what they said they were going to do. And then I think I've showed you 117 it deals with this in 124, which is on page 224 and 226. It was not enough for Fenris, this is at bottom of 226, paragraph 124, it was not enough for Fenris to prove that it suffered some loss. Instead, for the reasons given above, Fenris had to prove on the balance of probabilities that but for the injunction it would have invested in European small caps in the manner pleaded in the points of claim. Now, the points of claim we'll have a look at in a moment. But that is, we say, that when you look at the actual documents, doesn't make sense. Four things we say went wrong with this part of the judgment. The first is that just because the type of loss is alleged is pleaded, it doesn't mean that you need to prove more than that. It doesn't mean that on a balance of probabilities you have to plead more than that. It doesn't change the fact that the profits from a portfolio is a question of quantification, the composition of a portfolio, how much cash, how much leverage, what type of securities, that's all quantification. The Court of Appeal had no basis for ditching the orthodox distinction anyway, even on its own view, because all it did was shift the dividing line from whatever it thought the judge had used for causation to what it did. It never asked itself, now we know that he's going to have invested in something or other and suffered some loss, what's the quantum? If he invested in European small caps, or whatever they call them, Norwegian small caps, then that's some loss. So now it's a question of quantification. They don't actually deal with it that way at all. In fact, they accept a submission made by Ennismore, which is rather odd, because it looks like they're dealing with it as a question of loss of a chance. If you go to page 212, they recite the submission that Ennismore made at paragraph 76, which the judge deals with it rather oddly. The judge doesn't deal with this submission well, but the point is that the Court of Appeal says that paragraph 76 is correct. Paragraph 76 shows that what they then say has to be, after causation, you have to deal with it on a loss of a chance basis. Well, that's not right. After causation, it's a question of quantification. Paragraph 78, EFML contends its submission recited in 246 is manifestly correct, and the judge erred in rejecting it. And then if you go to page 223, you'll see that they accept that. And paragraph 114 and 116. So their approach appears to be wrong. They never remind themselves that quantification is then a question not of causation at all, and they should have done. So that's the first problem with it. The second one is when you look at what the pleading actually says. That I have to ask you to turn to the points of claim, which are at page 377 of the electronic bundle. And at page 379, you can see the pleading of loss in paragraphs 19 and 20. In much the same way. Not exactly the same way, in much the same way. He's obviously an investment manager is going to say, I would have invested it, look at my track record. Which is what he said.
Famous phrase, I would have done it my way.
Yeah, but my way being my track record, you know.
Yes, yeah.
Yeah. And it's not really giving you anything very specific in terms of causation. And you'll see that when they ask us for particulars, we balk at giving more detail. At page, particulars are at page 391, and the relevant particulars are at page 395, paragraph 10. You can't ask us about a hypothetical portfolio. That's a matter of expert evidence. We had a track record.
But what wasn't the key question for the judge and then for the Court of Appeal? How much risk would Fenris have been prepared to take with this money? And it's all very well saying you're prepared to take a lot of risk with other people's money and put it in this high risk, high yield things, which we know actually did very well over the period. But wasn't the Court of Appeal saying, no, we don't think that you would have done the same with your money. You would have put it in small caps, yes, but a much lower risk and lower yield. And of course, you're right, you can't make up a portfolio. So you take a proxy, which is actually a fund which exists, which invests in the sort of way that is proved on the balance of probabilities you would have invested, and you see how well that did.
Yeah, but
isn't that the choice between a risky small caps fund and a less risky small caps fund is what they were having to decide between.
Well, Milady, I understand the point, but as soon as you get into the level of risk, you're getting into the composition of the portfolio, the beta of the portfolio, the alpha of the portfolio, the shares. You're going to look at all sorts of things that are really to do with quantification. These are things about which we had evidence, a lot of evidence, which the Court of Appeal didn't consider. And the Court of Appeal should have stopped by saying to itself, well, he would have invested in equities, European. The judge dealt with the risk. He dealt with everything else. This is a matter of quantification, treated as such at trial, wasn't appealed. So can I just finish my citations, Milady, because I can show you a little bit more about what happened, and then we can return to the perhaps the equity of the question. But you can see
I missed your page number for the further and better particulars.
The particulars start, my lord, on page 391, and the relevant particulars are on page 395, paragraph 10.
Thank you.
And of course, here we declined to come up with a portfolio. We could decline to do that. And of course, that portfolio would tell you, and one of the ways that you deal with risk, just as your ladyship put to me, is you put a lot of it in cash. You have a bigger cash cushion. But that was dealt with at length by the experts who said that he thought 50% would be in cash. And then the court, the Grand Court, dealt with the cross-examination on that, dealt with the contrary evidence of that, and made findings. Well, not very terse findings, but it reached a conclusion. And all that discussion was about relative, well, a lot of the discussion was about relative risk, because Vigeland's case was that when you look at the portfolio, you should build in leverage, because traders have leverage. They get, in all sorts of different ways. They bump up the level of capital, and it becomes more risky, as we know. But there was a lot of debate about that. There wasn't any debate about that. The Court of Appeal didn't examine the record about the evidence on that. I'll just show you where you can see that. But at least in terms of the pleading, which is what the Court of Appeal refers to in its judgment, almost nothing is said about the form of investment, other than that he would have traded European small caps, which is a very big universe, and done it much the same way as he would on his track record. What else is he going to say? And then when you'll see his evidence in a moment. But then, of course, he then tries to quantify that. That's, of course, his exercise of quantification. The third reason why the Court of Appeal went wrong about this, it's completely inconsistent with the loss which the Court of Appeal then does accept, to say that there was no such loss. If we go back to the judgment at page 230, you see at paragraph 135, Ennismore proposed a calculation of the profit to be awarded to the judge if he found that Fenris had deprived of the opportunity to make a profit. Calculation was predicated on investment in small caps, not UK small caps. I mean, this was European small caps, with a bias towards Norway, still European small caps, and energy stocks, very much what Vigeland had been doing. That's how he had been investing, pursuing the same long-short strategy as Vigeland had followed at EFOR. Exactly what he pleaded. And then they put a 50% net long position. In other words, they had a lot of cash in their scenario, a rate of return that corresponds to the HSBC, that was the European Small Caps Index, and the OSECX, which is a Norwegian oil-based index. So what they basically do is they accept that exactly the kind of loss we pleaded is the kind of loss that he suffered, but they quantify it by reference to Ennismore's own calculations. And so they should have really at that stage said, well, we see that he would have invested in shares that in much the same way as he did, is what they say. It's what we pleaded. And then they should have said, well, it's then a question of quantification, and the judge did that. And it was fundamentally the fourth point. The fourth reason why the Court of Appeal shouldn't have done this is because, having reached the point where they said he would have invested in much the same way, it was unfair to do it in the way they did, just by reference to Ennismore's figures. Can I just ask you to have a look?
Have we lost Lord Sales? Let's see.
No.
We've lost his picture.
Milady might be right, because his wheels turning.
Ian, can you hear me? Nigel, can you hear me?
Hi, Lord Briggs. I'm not sure if Ian or Nigel can't see the. I can. I've messaged Lord Sales, see if his computer's work, and see if it's just his camera or his computer, but he's not got back to me. So.
Well, I think somebody needs to beat a path to his door.
Yeah, I'm just going to send a message via the WhatsApp group chat now.
We'll pause for a moment, Mr. Lowe. I'm sorry about this.
Not at all, Miller. Can I thank you for agreeing to do this? I know it was for my benefit.
No, it was the least worst option in the circumstances.
Thank you, Miller.
Hi, Lord Briggs. Just to let you know, Ian is on his way up to Lord Sales now.
Good. We're momentarily paused, but I don't think there's a need to turn off the live feed. Gentlemen, I'm told that there's some problem with Lord Sale's computer. I think it might be sensible if we paused for 5 minutes so we don't all have to sit staring at our screens, and resumed at 12:30, at which time either it will have been fixed or we'll have found some other solution.
Thank you, my lord. Court of Appeal to then embark on their own quantification without recognizing that, first of all, that hadn't been appealed, and that they weren't actually looking at all the evidence in the round properly. There was a great deal of evidence on quantum. I'm just going to very quickly show you what it was. We don't have all of it.
Just before you do, Mr. Lowe, if you look at page 227 of the bundle,
Yes, my lord.
you see, or maybe 228, hold on, my page numbering is playing up, but it's paragraph 127.
Yes, my lord.
One finds the summary of the Court of Appeal's reason for setting aside the judge's order,
Yes.
which appears to be a straight rejection of the pleaded case as they defined it. And then at 128, they record your accepting that if the court was to set aside the judge's award in that way, it would be open to the Court of Appeal to substitute its own finding as to the compensation which Fenris was entitled to. In other words, to do the job again. Okay.
Well,
Is that concession correctly recorded by the Court of Appeal?
well, what they were saying was that they were going to set aside the finding of causation, and then it was, if that was right, and we didn't know we didn't even know how they would then find causation, because it was a debate in court. They didn't say, oh, well, we'll find it on this basis. Then it's up for grabs, because then the best thing I could have got was interest. You know, something a little bit better than it, compound interest. I don't know at the stage when they're telling me that they made it pretty obvious during the hearing that they were going to set aside the judge's finding on causation, because that's what had been appealed. But then, in order to give me something, they would have had to have some alternative theory of causation, which we didn't agree that. So we canvassed options.
But you didn't object, as I understand it, to the Court of Appeal as using your way of describing it, doing causation again.
Well, no, we asked them, we invited them to find causation, but then they found causation on a basis that was, well, not really debated at all, because what they find is causation that gives rise to the loss in paragraph 135.
Yes, no, I understand. Thank you.
And by that stage, we were sort of.
Can I just ask? Could you just you're using this word causation, and I'm not sure whether you're using it in the sense that I generally understand it. So could you just express what it is, what aspect of the case you mean when you say a finding of causation? What is the finding of causation by the judge, and what is the finding of causation that the Court of Appeal said? Could you just sort of express that as the finding of fact?
Yes, the judge finds that we suffered some loss, that we proved on a balance of probability that we've suffered some loss. And he then says, I now turn to the question of quantification. And some loss in this context means that I would have made some profit from a portfolio investing in much the same way as I did before. I would have invested in a portfolio of securities in much the same way as before, and I would have made profit, so I suffer some loss. That's the finding of causation. That's how you find causation in a case like this. That's what you would have done in parabola. That's what you would do in this case. And the judge says he deals with the question that of some loss, and then he says, now I'm moving on to quantification. He deals with it quite tersely, but he deals with it as such. There's a dividing line at that stage, because I have to prove on a balance of probability that I would have over time suffered some loss from not having that portfolio. That's causation. Milady, that's my submission.
Right, but you're not saying, when you say some loss like that, I was thinking you meant as opposed to no loss, so some minimal loss of the kind that would complete a tort action, for example.
Well,
but then you say you would have caught that finding that there was some loss involves finding that he would have invested in the European small caps in the same way that he had previously done. So that's not talking about a nominal minimum amount of loss then.
Well, at the stage when you find that he would have invested in, and it's not in Madoff, but it's in something, then it's not difficult, and you have a couple of cases which help you on this in inquiries about prima facie inferences. It's not difficult to infer that you would have made some profit, maybe not even as much as interest rates. And if you do infer that from not having a portfolio of investments, it's unheard of to have a portfolio of investments and then not doing something unless you've invested in fraudulent vehicles. So if you assume that at the point, whatever the investments he had, however you look at the pleading and whatever you then find in terms of causation, it's not difficult to infer some loss. As soon as you do that, you're then in the difficult position that you have to work out, well, how much, and then you have risk and what kind of shares, what balance of shares, how many Norwegian shares, how many index funds, and so on. But that's quantification. That's why you can't possibly do that as a question of balance of probability proof, because you'd have a trial that lasts for 5 years, and it will all be hypothetical and it would all be nonsense. So the courts have said, when you get to that stage, that's when you've got to let us use a broad axe. You've got to let us do the quantification in a much more less scientific way, because you can't do it that way. And the judge heard a lot of evidence about that and then formed his view. But the way causation was pleaded and the way causation was accepted in paragraph 135 is not any different. That was my point. And yes, they make a finding, but that finding is inconsistent with what they then do. I completely accept they make a finding expressed to be absolutely against me in 127 and 128, and then incomprehensibly come up with that loss. Can I just very quickly show you the evidence? Because my point here is that if the court were going to embark on quantification, they really should have not just looked at Ennismore's calculation. But I can do this quite quickly. I just need to show you a couple of documents, if you don't mind. Page 416 is Mr Vigeland's witness statement. And at page 422 and 423, and at 422, paragraph 31 at the bottom, he then comes up with his quantification, and it's all prefaced by "but for the injunction." He then says what return he made over time. He then compares it to HSBC index, which is the index that we were looking at, and also Ennismore's own performance. And then he comes up with his average outperformance and so on. And he supplements that in another statement. He corrects something, and that's starts at page 499, and he makes some corrections to that at page 504 to 506. And the detail doesn't really matter. We then have a witness from Ennismore who also deals with this stuff at page 430 and page 535. So 2 statements from him, 2 statements from Vigeland. And then we have the expert who's at page 441, his first report. His second report is at page 479. His third report, corrections and amendments, is at page 492. And his fourth report, second supplemental, is at page 545. So we had a lot of reports, a lot of statements, and a lot of cross-examination. You only have in the bundle the cross-examination of I think, Mr. Vigeland, but we also had cross-examination of Mr. Blair and Mr. Croft, and we had a number of supporting documents that were looked at and so on. And the judge, when he looks at this evidence, he's quite skeptical about it. He considers the evidence at paragraphs 93 to 175 of his judgment. I won't trouble you with that. I'm just going to show you a couple of references where he deals with it dismissively. and said he's going to form his own view. The first one is at page 45 of the electronic bundle. It's page 45, yeah, 45, paragraph 113. None of these mathematical exercises in any way influence the court, which will make its ultimate evaluation on a wider set of approved principles. Paragraph 128 on page 50. He says he doesn't intend to resolve the case on the basis of a statistical analysis. Sufficient to remark that Blair takes issue with Vigeland's calculations. Page 54, paragraph 135. Sufficient to note differences of viewpoint rather than attempt statistical study as to whose viewpoint is right and whose viewpoint is wrong. And then at page 55, he says at paragraph 137, quite apparent different people have different views about all this stuff. Paragraph 60, page 68, paragraphs 172 into 173. He says, you can see what he says in paragraphs 172 to 173, expresses a skepticism about it, and the practical assistance to the court of all this material is really very limited. Results differ depending on the precise parameter. And then at page 70, he says he wants to use a paragraph 176, broad factors, and page 71, paragraph 179, he says against the same thing. And his conclusions then at page 103, paragraph 285, turns to the question of quantification, critical important principle in the context of the incident case, foreseeability, 290 to 294. He very tersely and briefly sets out his conclusions on the welter of evidence he's heard over a very large number of days and the long submissions he's received. It's clear in the judgment that he didn't accept all the calculations. It's clear from the judgment that he considered all of them. He had a lot of evidence about them. And he used them as a rough yardstick. And although not expressed in great detail, his conclusions on quantum are clear. We then come to the appeal, and in the grounds of appeal, which I think you'll see at page 305, you'll see that there are, if you were to peruse the following 4 pages, you will see no attempt to engage in quantum, not an attempt to engage with any of the evidence on quantum or loss, and it wasn't suggested it was wrong. In the appellant skeleton, which starts at page 310 before the Court of Appeal, there is no attempt to challenge any of the evidence on quantum or the judge's conclusions on quantum. When we put on our skeleton, I think this answers Lord Stephen's point, I hope, or deals with it, maybe just briefly. Page 336. Paragraph 2. We make the point that Ennismore didn't challenge the loss that would have been suffered by Fenris had it reinvested its frozen funds. Macmillan's computation over that period stands. It's not suggested this is wrong or that a discount should be applied and so on. And when they reply to that, which is at page 355, there's no challenge to that. No one says that, oh, you got that wrong. We are actually challenging the calculation of quantum. Ennismore's approach was to require us to prove as much as possible in that hypothetical exercise. So we say that the Court of Appeal acted unfairly. If it was going to redo quantum, it should have realized that the judge had actually already done that exercise. And he'd done it by reference to arguments about the level of risk. He'd done it by reference to the level of shares you would have had in the Norwegian oil shares, the much safer index, whether it was a tracker or whether it wouldn't have been, how much cash would have been there, how much leverage. He actually dealt specifically with evidence about leverage in his judgment. So in those circumstances, what all the Court of Appeal actually succeeded in doing was confirming his finding of some loss. And having an appeal where that is the issue, because Ennismore lost on that, that is actually not what Ennismore asked for. That's where we ended up. The Court of Appeal put us both in a spot at the end, come up with something, because they obviously thought there had been some loss. They shouldn't have got into quantification.
I'm conscious that your time, as agreed, runs out at 1 o'clock. I minded to give you an extra 5 minutes because of the delay, but I'm
don't need to.
Well, you're going to at some stage deal with the duration point.
I'm just coming to that now.
That's fine. Okay, thank you.
Now I've explained to you that what the debate is about in the loss period. The Court of Appeal dealt with the loss period at pages 221 to 222. This is in paragraphs 107 to 110. They dealt with it, if you've seen it, primarily as a question of construction. They didn't really want to get into the causation issue. The judge dealt with it in two ways, two alternative ways. Page 132, paragraph 77 to 89, and page 135, 83 to 89 is the causation argument that we were running. And my submission is really this: if you look at the injunction and the variation, and you ask yourself what would have happened but for those in a counterfactual world, and then you ask yourself what effect does, first of all, discharge of the injunction have, and secondly, the supervening judgment. In the counterfactual world, you will see that doesn't destroy the cause of the chain of causation. What Justice of Appeal Field said was eclipsing it. Just it doesn't take account of the fact that you're engaged in a counterfactual world. So assume that the freezing order, I just illustrate this, assume that a freezing order deprives a defendant of the ability to buy a one-off profitable asset. It's a business which over 10 years projected would make huge profits. Alternatively, imagine a company where the working capital to exploit a valuable business opportunity can't be used because of a freezing injunction. The injunction is discharged after year 3. Does that mean that the defendant doesn't continue to suffer loss beyond year 3? And in a counterfactual scenario, those profits would have continued. What you do in year 4 when you have the inquiry is you find a net present value of that stream of profits. You apply perhaps a discounted cash flow to reach that, but that doesn't alter the fact that after the injunction is discharged, you're still valuing the future cash flows after that. And there's nothing in the discharge of the injunction that should stop that. And there's no wording in the order in any injunction, any undertaking, that would mean any hypothetical damages that continue to accrue because of the injunction you can't recover. And there are cases that support that, and we put them in the case. Just give you the reference without taking you to them. One is a Canadian case, Algonquin Mercantile, which is at the page 1048, the relevant passage is 1058 at paragraph 37. There's a Jamaican case which went to the Privy Council called Pfizer and Medimpex. This part didn't go to the Privy Council, and I think you'll find the relevant references on page 1646. No, it's 1763. The case is at 1646. And G refers to the Canadian case, and the reference is at 1953. And in our case, it's dealt with at paragraphs 34 and 35 on page 890 and 896, I think. The Court of Appeal simply held that the discharge of the injunction discharged the undertaking, and we say, well, that fails to recognize that the loss that's occurred before the discharge of the injunction, which is with which you're essentially pregnant at that point, can still be recovered. The focus was, in their judgment, on discharge. Then you ask yourself, in the hypothetical counterfactual inquiry, assume, as happened here, that a judgment is given at the same time against the defendant, an erroneous judgment, which is immediately appealed. Now, if you examine that as a matter of logic on the counterfactual hypothesis, you've introduced two known events, the judgment and the appeal. And then what would the plaintiff, of course, will say to you, well, you wouldn't have had anything at that point because you had to pay the judgment, which is what Ennismore say. The defendant, on the other hand, will say, well, I would have had a profitable asset at the date of the injunction, and that would have continued, and it would have been profitable over time. And the court wouldn't have required me to liquidate that portfolio. It wouldn't have required me to sell it. Maybe I could have got a stay, or I could have agreed a condition for the opposal, to keep the portfolio. Now here we have Fenris has the order made in February 2009, and it was varied to require payment into a Butterfield bank account in the Cayman Islands. The order could only be made in that way because Fenris is a Belizean company. Mr Vigeland, its principal, is a Norwegian. The only reason that there was money in Cayman was because he was redeeming his investment out of Ennismore's fund, and Ennismore was registered in Cayman. So, but for the order, he would have had access to that money. He didn't have a Cayman bank account, which is why they had to set up a joint Butterfield account. And there's no reason to believe that that money would have been anywhere near the jurisdiction. It doesn't mean it would have been in Vanuatu. It doesn't mean it would have been in some completely inaccessible place, but it certainly wouldn't have been in the Cayman Islands. And the hypothetical inquiry, if you accept causation, is that he would have invested the portfolio in much the same way as he had at Ennismore, Norwegian shares, oil shares, whatever it was, and built up a portfolio. So 3 years later, when you get to the judgment, which we immediately appeal, the question is, Ennismore is not in the position it would have been with a freezing order. It can't simply get the money that's in the account turned over to itself. It then has to go and look to enforce that. We're not doing anything wrong by not immediately paying that up because we're appealing. Ennismore might say there should be a condition to our appeal that we pay it into court, but the Court of Appeal would then be met by Fenris saying, well, requiring us to liquidate this is wrong because we're trading profitably, it's our trade. We can perhaps give it to custodian, we can perhaps give you some transparency, the custodian can give you reports, liberty to apply if we buy Madoff, that sort of thing. But there's no inevitability that the money would have simply disappeared after judgment. So
I just want to stop you before I get too far away from your submission that a person who has suffered a judgment which he is appealing does nothing wrong by not complying with the judgment. Do you have any authority for that proposition? It strikes me rather surprising.
Well, it's an order. It's an order that it's made. It's not a contempt because you've got an order for payment, and that's not paying that pending appeal.
The last thing I'm doing is suggesting it's a contempt, but your submission was that there was nothing wrong with not complying with the judgment so long as you appeal against it.
Well, I'm saying that if you say to the other side, we're good for the money, we will pay it in due course. It's in a trading portfolio. We're not going to liquidate it now. Then you're not doing anything dishonest.
I didn't suggest that you were doing something dishonest. Your submission was there was nothing wrong.
Oh, I see. Okay. Well, it's not. I mean, you've got Patel and Mirza in your authorities. It's not Patel and Mirza. It's a counterfactual scenario where the whole reason you have a freezing order is to make the order easy to enforce in circumstances when it wouldn't otherwise be easy to enforce. And here what you have is you have a situation where in a counterfactual scenario, you wouldn't have the money in Cayman that was simply turned over into Butterfield bank account. The question then arises, what would have happened after judgment? And all sorts of things could have happened. I could have gone and asked for a stay if I wanted to own up and pay the money, but I wanted the Court of Appeal to recognise I had a reason for not doing so, and I had a good appeal. And the appeal succeeded in the end.
Well, the Court of Appeal might well require you to bring the money into court, or at least into the jurisdiction, as a condition for allowing you to pursue the appeal.
Possibly, but it might have said, look, we can see this is with Credit Suisse, it's with the custodian. We're getting monthly statements. Your solicitors can give an undertaking. You're trading it successfully. You're a very successful trader at this point, given the judge's findings about quantum. And so we're not going to make you liquidate the portfolio. That's the point. Who would have made us liquidate the portfolio if we'd given some assurances, transparency, custodian, something? And in those circumstances, if there's the only thing that would break the chain of causation is if the Court of Appeal would, as a matter of course, said, right, you've got to sell that portfolio, you've got to liquidate all these securities, you've got to put up cash in court as a condition of the appeal. And that is, I would respectfully suggest, quite a large leap, because the natural inclination is to say, well, why would the court, seeing that you've already made profits well above the Moreva level? Sorry, I call it Moreva because it's what we call it here, but it's the freezing order, well above the freezing order level. Why would the court then say, oh, well, you must liquidate that portfolio? And that's what would break the chain of causation. And I wanted to just show you, I'll give you a reference to it. There's a case called Shiblak, decision of Mr. Justice Saville, which is dealt with by the Court of Appeal in a case called SCF Tankers, which is starts at page 1767. And this is my last point, penultimate point. In that case, at page 1779, paragraphs 43 to 47, well, paragraphs 43, 46, and 47, you will see that what the Court of Appeal say is that the test of causation in an inquiry is dealt with by getting the claimant to show a prima facie case. Now, prima facie, we say there is no basis for supposing that a Court of Appeal, fully informed of the facts that we had a profitable portfolio in a counterfactual world, would have required liquidation of that portfolio, prima facie. And so the judge said he didn't like prima facie, and the Court of Appeal said they didn't need to deal with it. Quite why, I don't know either, perhaps because they found causation without it. But at least in terms of this part of the inquiry, when you're still looking at it as to whether or not the judgment eclipsed it, we would say you find causation, sufficient causation, prima facie causation for the judgment not to make any difference. So the one thing that happened here in the real world, which would not have happened in the counterfactual world, is that as soon as the judgment was given, the funds were turned over to Ennismore for Ennismore to keep, and then we couldn't have gone to, a stay would have been, a stay in terms of cash execution was obviously going to be much more difficult. Ennismore is a big company, well worth that money. So we didn't get it back until they decided to give it back after the Privy Council had ultimately dismissed their appeal. And my Lord, I don't know if I've answered all your questions, but those were my submissions, and I hope I've reached exactly the right point.
You certainly have, Mr. Lowe, and you've made up the 5 minutes which you lost through no fault of your own. The court will, I think, briefly wish to confer, or board will wish to confer, and we'll resume, I think, to allow everybody to get into one place at 7 minutes past 1. And Mr. McMaster, that won't give you too little time, will it?
No, my lord.
Very good. Well, 7 minutes past 1, we will resume. The hearing is resumed. Mr. McMaster.
Lord, I'm going to address the board firstly on the basis on which the Court of Appeal calculated the compensation payable pursuant to the Clough undertaking. When we look at this, it's important to understand the context in which the Court of Appeal was giving its judgment. And the starting point of that is to understand the way precisely in which the case was put in the pleadings and then run at trial, which you can turn to page 395 to see. 395 is the further and better particulars that we looked at when Mr. Lowe was addressing the board. And it begins, the relevant passage begins with the allegation in paragraph 20, which is that factual allegation he would have investigated the funds in a portfolio of European equities with a relatively small market capitalization. And you've seen the answer to the particulars that were requested there. But what Mr. Lowe didn't take you to was the next question under paragraph 21 on page 396, which is important. The question went to a passage in the text, in the premises, Fenris has suffered loss and damage, and then it identifies the loss, namely the lost profits it would otherwise have been able to make. And that's a reference to the profits on investment in the portfolio of equities, or the lost opportunity to have its funds invested properly. Now, we wanted to be sure we understood what case we were going to have to meet on lost opportunity, because it was possible that it was a different case from the one on investment in equities. Request, please confirm that the case on lost opportunity is that the case in funds in question would have been invested in European equities. Next question, if it's being alleged that any other opportunity was lost, please give full particulars of the opportunity lost together with the sort of particulars you'd expect and quantify the losses claimed. Answer, confirmed. So the case on lost opportunities is a lost equity small cap investment opportunity, and there is no other case on loss of opportunity being advanced. At this point, I'd like to go to a subject raised by Lady Rose, which is the way Mr. Lowe was using the term causation. There are, on a conventional analysis, 3 things you need to look at when assessing loss. You need to be satisfied, the court needs to be satisfied that the plaintiff has proved the loss that it alleged. It needs then to, if it concludes that the loss that's been proved was caused by the tort, breach of contract, injunction or whatever, then it needs to go on to quantify that loss. The case here was that if Mr. Vigeland was free to do what he wished with that money, he would have invested it in European equities. And the loss that he's alleging is the loss that flows from him not being free to do that. There was no real question of causation if he proves that, because it's obvious that the injunction was the cause of that loss. So what we were really looking at was not a question of causation, but a question of proof of loss. Now, the judge found, as we know, for Mr. Vigeland on that question. What happened in the Court of Appeal was that the Court of Appeal found that the judgment was vitiated by a series of errors, some of them described as serious, and one of them involving remarks that Mr. Lowe himself accepted were indefensible. And so, unsurprisingly, the Court of Appeal felt it had to set aside the judgment. And there's no issue on any of that. And as my Lord Briggs identified, the judgment itself, judgment of the Court of Appeal at paragraph 128 on page 229, records a concession that Mr. Lowe made, that if the court were to set aside the judge's award in favour of Fenris, the court could substitute for that award its own findings. And that's a concession that, as far as my recollection of the hearing goes, is correctly recorded in the judgment. The way in which the Court of Appeal went about this assessment was of course affected by the way in which the case had been pleaded in advance, because it was an all or nothing case. And I'll take you to what the Court of Appeal found. The Court of Appeal, first of all, has to ask itself the question, do we find on the balance of probabilities that Mr Vigeland and Fenris would have invested the money in the manner alleged? And the way to understand exactly what the Court of Appeal was doing is to look at page 226 to pick up the train of thought. And the bottom of page 226 contains a heading, should there be a reference back to the Grand Court for a finding, whether Fenris, but for the injunction, would have invested the frozen funds as pleaded in the statement of claim, or should the court decide this question? So the question that we're going to see the court addressing now is the question whether, on the balance of probabilities, Fenris would have invested the funds as pleaded in the points of claim. Paragraph 125 is the reasoning of Justice of Appeal Field on the question whether the court ought itself to decide that question. So he's looking at the adequacy of the material. And what he's essentially doing is saying that the necessary material is there to allow the Court of Appeal to substitute its own finding. And again, there's no issue on this. There's no ground of appeal that says the Court of Appeal should not have substituted its finding. And I'll show you how it's put in the grounds in a moment. And the conclusion is, in the last two lines, in my judgment, the Court of Appeal has the necessary material to decide the aforesaid question, namely whether on the balance of probabilities there would have been the investment in European equities as pleaded. And so the answer to the question we see on page 228. And that's the paragraph that my Lord Briggs has referred to. And I'd like to just read it out fairly slowly. Weighing the matters set out above, I find that they do not, on the balance of probabilities, give rise to the inference that but for the injunction, Fenris, acting by Mr Vigeland, would have invested the frozen funds in European small caps, as pleaded in the points of claim. My reasons are as follows, and then he gives three reasons for that conclusion. So, Justices of Appeal Field, with whom the other two Justices of Appeal agree, found that the evidence did not establish the proposition that had to be established for the pleaded case to succeed, did not establish it on the balance of probabilities. The pleaded case therefore failed. And that is the context in which the Court of Appeal came to find itself in a position of having to make a substitution. And if we look at the way it was dealt with, after the concession from Mr Lowe at 128, there's a further passage on paragraph 129, which reflects an exchange during submissions. I was asked, would I accept the Court of Appeal, if it were to set aside the finding of the judge, could substitute a finding which involved investment other than in a portfolio of European small caps managed in the same way as they were managed, as Mr Vigeland managed the investments at EFML. And I accepted that the Court of Appeal could do that. And so what the Court of Appeal is now doing is describing how, once the factual basis for the pleaded case is completely struck away, it's going to make what's in the authorities described as a liberal assessment on some other basis, on the basis that the money would not have done nothing. But it's got no material. It's got no material to do this because of the way the case was pleaded and advanced, because of the all or nothing case. I think none. It's got very little. And I attempted to give the court a way of dealing with the absence of material by suggesting a rate of return of 5 to 10%. That's recorded in paragraph 130. And then at paragraph 132, the judgment explains that the court has to make the best possible assessment of the profit which Fenris would have made, taking account, allowing for all of the uncertainties, with the view to determine what profit there was an overall chance Fenris would have made. That's the exercise in which the court engaged by reference to the Allied Maples and Privilege authorities that are referred to there. And again, there's no challenge to that approach in the grounds of appeal. And then at paragraph 133, using this overall chance approach, Justice of Appeal Field concludes that there's an overall chance that Fenris would have used the money to make an investment that was less risky than a portfolio of European small caps with a lower and safer return. And so what we've got is a finding that the money would have been invested in a different class of assets.
Mr. McMaster, can I just make sure I understand the, if you like, the argot that the Court of Appeal is by this stage using? When they say less risky than a portfolio of European small caps, they don't mean than any portfolio of European small caps, do they? They mean the one of the type in which he said in his pleading and his affidavit he would have invested it.
My Lord, I think it's fair to say it's unclear. It's unclear. And it's certainly the latter, certainly not in the way that he'd formerly been doing it, but it also maybe not in European small caps at all. It's not entirely clear because what Justice of Appeal Field didn't go on to do was say anything more about that alternative to investing the money than is in paragraph 133.
Well, except that at 135, they accept, I think, what you essentially proffered to them, namely an investment in small caps with a bias towards Norway and energy stocks.
Yes.
Which sounds awfully like an investment in European small caps.
Yes, can I come to that by going through paragraph 134?
Yes, all right.
Which is that, as Mr. McMaster observed, there's very considerable uncertainty as to what the rate of return would have been on the type of investment. I find there was an overall chance that Fenris would have made. So he uses this formula to refer back to what we've just looked at, a less risky investment. And then in paragraph 135, there's a reference to my closing submissions, and Mr. Lowe's taken you through that. And at paragraph 136, what the judge says is that faute de mieux, meaning because we've got nothing else, that calculation affords a reasonable basis for us to conclude that there was an overall chance that Fenris would have achieved an annual rate of return of 8.5% on an investment of the type I have found Fenris would have made. And so, my Lord, my reading of that was that the reading I submit the board should settle for is that the Court of Appeal is not making a finding that there would have been investment in European small caps at all. It's making a finding that there would have been a rate of return of 8.5% on the very broad brush approach that you're forced to take in circumstances like these. And another way of looking at this is to say, well, actually that calculation doesn't really provide very much of a basis for that 8.5% figure, given that the Court of Appeal had said that it had not been proved that there would be investment in small caps, and that it thought that the investment would have been in a less risky type of asset.
Well, there's European small caps and European small caps, aren't there? Because what's a small cap? It covers a vast range of different companies, some of which are very small and some of which
Yes.
I would think of as not being small.
Yes.
But I think if I can sort of ask a question, which I think is probably the same question as my Lord Briggs was asking, is that when the judgment refers to capital E European, capital S small, capital C caps, is that a term of art, meaning not just all European small caps, but a fund, a specific fund, like the fund that he previously invested in? Is that what they mean by European small caps when it's used when it's capitalized like that. Because you can then it makes sense to say, I don't think they would have invested in European capital S, small capital C caps, but I think they would have invested in European lowercase s, lowercase c, of a different, less risky kinds, more towards the 2 billion than the 300,000.
Yes,
capitalisation.
it's certainly a conclusion that there wouldn't have been investment in much the same manner as at Ennismore.
Well, that's what the Court of Appeal seems to have gone out of its way to explain in paragraph 127.
Exactly. So it's certainly a finding to that effect. And whether it's a finding to that effect or that the asset class would have been avoided altogether, I don't think really matters by this stage, because here is the Court of Appeal trying to help Mr Vigeland, who has found himself with a case that he's pleaded. He's taken a tactical risk, and it was his strategy probably to try and put the judge at first instance in a position of giving him a lot of money or nothing, and Hobson's choice. And the Court of Appeal, that strategy having failed, is trying nevertheless to be fair to him and give him something. And that's what Mr Vigeland comes to, Fenris, comes to this board complaining of. And I say it's completely wrong. The right result was reached. And that's really all there is I have to say on the first point, unless I can assist the members of the board any further.
I just have some difficulty with the concept of chance, overall chance. Take paragraph 136. It says there was an overall chance. But then it goes on to say, I have found that Fenris would have made. My perception of a chance is that if you find that somebody would have invested in a particular hypothetical group of investment, there may be a chance that may go up and down. So you discount the amount given the risks of the investment. But my understanding is they actually made a finding that he would have invested in a less risky investment that had a return of 8.5%. And I just have difficulty in seeing how you then discount that for a chance, on a chance basis.
Yes, that's absolutely right. At 133, the finding is a lower and safer return than that portfolio. Can I suggest, my lord, that the reference to overall chance, which we see beginning at paragraph 132 on page 229, is a reference to a passage in the judgment of Justice Mayles, as he then was, which we can see at page 1134. This is paragraph 58, and this is dealing with one of the heads of claim in the Privilov case of first instance. The judge explains that there's necessarily a degree of uncertainty in determining what Mr. Keating would have done with the money if it had not been held in the Lawrence Graham account as security for the claimant's claims. And this is money that the judge actually decided would not have been invested in any significantly different way, so he didn't award any compensation for this particular frozen fund. Even if it can be said with reasonable confidence what he would have done or sought to do, for example, he would have sought to invest in a program of new build, there remains considerable uncertainty in assessing the financial outcome which would have resulted. However, those uncertainties are not fatal to the defendant's claim. What the defendants need to prove is that on the balance of probabilities, they would have sought to invest in a way that had a real as distinct from fanciful chance of making a profit. If so, it would be necessary to make the best possible assessment of the profit which the defendants would have made, taking account of the uncertainties inherent in this case. In a case such as this, where there are a number of such uncertainties, what needs to be assessed is the overall chance of the defendants making the profits in question. I would suggest that's what Justice of Appeal Field had in mind, and that's the approach that he's taken.
But what he did, in fact, I mean, I did the calculation that he's done, the 2 years and 276 days at 8.5% gets you to roughly 515 €5,000. And that's then what they award. They didn't. One might think that if they were really confused about loss of a chance, they would have said, oh, and we only give you 50% or 65% of that because you might not have invested it in that.
Yes.
And that would have been a misstep. But they didn't actually do that. They didn't make any deduction for the fact that they might not have invested. They gave them the whole of the loss that they would have earned if that had been how they invested it.
That's exactly right, my lady. And I think that's an indication that they weren't looking at it as it's in a discounted loss of chance way, but rather the way that Justice Mayles was describing in the passage that I've just shown you.
I mean, it seemed these passages that perhaps in the Court of Appeal that there was a bit of slippage in the language that they used, but I didn't think that they're gone wrong in principle. If one starts from 127, which my Lord Briggs had pointed to, there they clearly are looking at what Fenris would have done, balance working out how they would have invested. When one comes, they then, if I sort of may respectfully refer to it as a bit of slippage in paragraphs 132 and 133 when they talk about an overall chance. That makes it seem though they've moved away from the conventional analysis of looking at what the claimant had done, assessing what they would have done on balance of possibilities, and have done some sort of more holistic loss of a chance exercise. But in fact, when one comes through to the latter part of the analysis, at paragraph 134, there is a specific, there's a sort of mixture of, I find there was an overall chance would have met, which seems to sort of mix two things. But then 136, we're back to investment of time I would found this would have made. So it seemed to me that literally, and this is with paragraph 58 in Privilege, that they're looking at a balance of probability approach, what sort of investment would have been made. Looking at the appetite for risk that the claimant would have had and chances that obtained at that time. And then thereafter, they're really looking what follows, as my lady said, as not counting for being loss of a chance and things like that. In a sense, the chance element has been built to the assessment of what form of investment would have been made by Fenris in the first place. I put that forward to see if you've got anything to make about that.
No, I don't, my lord. I think that's helpful because the starting point is a lower rate of risk, and they've identified a portfolio of investments which does have a lower rate of risk, which I put forward. I think it was 8 1/3, and they've looked at that, tinkered with it, and given it 8.5, and said that's a reasonable basis for assessing the loss.
Thank you.
Well, then I would go on to the question of duration of loss, and there are two aspects to this. One is the finding of the Court of Appeal that the freezing order came to an end when judgment was given by Foster J in the action, and that's not appealed. The only ground in relation to duration that raises a question, mentions the question of construction, is a ground which postulates that you can't say, as a matter of principle, that if a loss occurred after the date of the freezing order coming to an end, you can't recover for it under the cross undertaking. And I completely accept that. On the right facts, you can. And the Court of Appeal didn't, I would respectfully suggest, say otherwise. The point is that there wasn't a case made out for such a loss. And if I can explain that by reference to the pleadings again, the Ennismore's points of defence at page 384 address the position at the conclusion of the trial when the judgment was entered, and that's paragraph 21. And what we aver there is that Fenris claims to be entitled to compensation under the undertaking and damages for lost investment profits between 27th of February 2009, which is the date Justice Foster entered judgment, and 25th May 2016. But from the 16th of February 2012, the reason, the 27th of February 2009 was the date of the freezing order. 16th of February 2012 was the date of Foster Joe's judgment. The reason that Fenris did not have the use of the money it claimed it would have invested was not the 2009 freezing order, but the judgment and the consequential order for payment to Ennismore. And to understand that, the board can turn to page 749, which is the order made at the conclusion of the trial. After the recitals that the courts decided, has tried the claim and determined that the plaintiff is entitled to receive the shares, or by this time the proceeds of sale, because as Mr. Lowe told you, the proceeds have been paid into Butterfield Bank. There is first of all a declaration that the plaintiff has since 31st of January 2009 been entitled to receive a transfer of the following shares held in the name of the defendant, callback shares, or of the proceeds of sale of the callback shares, such that proceeds amounting to a figure of 2.27 million euros. And then paragraph 3, there's a direction, there's an order that the defendant is to pay the judgment sum and interest to the plaintiff as follows. Within 14 days, the defendant will do or cause to be done all acts and things as are necessary to bring about the irrevocable payment to the plaintiff of monies held in the Butterfield account by way of payment on account of the judgment sum. And then the balance, which is represented by monies owed that presumably have been taken out for payment of legal expenses and other deductions that have been allowed along the way, has to be paid separately. Now, on the question that Mr. Lowe raised of whether or not that in this counterfactual world, Justice Foster would have ordered, had there been no freezing order, allowed a stay, there's very little for this court to go on in order to reach the conclusion in favour of Mr. Lowe that he's contending for, because he, having failed on his primary case in front of the Court of Appeal, we simply have a rather nebulous type of portfolio. But we don't have, and we didn't have, any evidence from Mr. Vigeland that he would have taken any particular approach or done anything in particular if he had been faced with a situation where there'd been no injunction and he'd invested the money elsewhere. All we do know is that on page 752, sorry, just check my references. At page 752, we have an order, which is the order that was made after Fenris asked for the handover order that I've just shown you to be stayed pending the appeal to the Court of Appeal. And the order recites that upon Fenris's application for an order that the enforcement of the order of Justice Foster of the 16th February be stayed pending the outcome of the defendant's appeal, hereby ordered the application be dismissed and the defendant pay the plaintiff's costs. Now, that was an application to stay an order affecting money in a Cayman Island bank. And the order was refused. There's no reason to think that had this been in a Swiss bank or a bank in Belize or anywhere else, that there would have been any different outcome. But the real problem is that this counterfactual wasn't pleaded or explored in evidence, and that's despite it having been this issue been raised expressly in Ennismore's defence. So, as you will have seen from my submissions, the only way the counterfactual is plausible is if one assumes that in Defiant that the money is parked outside the Cayman Islands, which is what Mr. Lowe has suggested. It's beyond the reach of the enforcement processes of the Cayman Islands. And the money, in defiance of an order refusing the stay and the judgment, the combination of those two orders, carries on being invested. And that's a finding that the board is being asked to make on relatively little evidence and a lot of conjecture.
The money that was invested in the European Small Caps Fund when Mr Vigeland was working for Ennismore, where was that situated?
It was situated that the bonus elements were retained in Ennismore funds. So part of Mr Vigeland's bonus was retained in funds that were managed by Ennismore.
And where were they?
I think one of them was a Cayman fund. It was in the Cayman fund, I've been told by Mr. Blair.
The assessment of damages is on foot of an undertaking to the court, and the court has a discretion as to whether or not to award damages. So what impact, if any, does the fact that one party is postulating that they're not going to comply with the court order have on that assessment?
Well, I think Mr. Lowe may contest that, but yeah, that's dealt with in my skeleton argument. There's a fundamental requirement of consistency in the law, which underpins a lot of the debate about public policy. And if I can refer to what I say in my case, which begins at page 892 and quotes extensively from a passage in Patel and Mirza. The position would be if the court was being asked to compensate for an investment gain that could only have been made by defying a court order, then the court ought not to give that compensation, because it's not, in the terms of the undertaking, a loss for which Fenris should be compensated. And the fundamental reason for that is the principle that's explained in some detail by Lord Sumption, if I can just have a moment to find it. Sorry, maybe quicker about a bit more paper. It'll be page 904, my lord. 903 to 904. If we start at the bottom of 903. The way I've approached it is to say that obviously not every consequence of the order falls to be compensated, and there's a question of scope of liability, which is the question that arises from the word should be compensated. And as to that scope of liability question, if the matter is proved factually, the scope of liability question would be, should Fenris be compensated for returns on the capital sum of 2.2 million that it would have had as a result of refusing to comply with the order of Justice Foster of the 16th of February 2012? The answer to this question has to be a resounding no. any other answer would, we submit, fringe what Sumption described in Patel and Mercer as the principle of consistency. And we refer to the passage in his speech, which I'm sure the court, members of the court have read at least once before. But he refers then to the judgment of McLaughlin J. In Hall and Hebbert, by the current fashionable concept of public policy. The problem remains the same: under what circumstances should immoral or criminal conduct of a plaintiff bar the plaintiff from recovering damages to which he or she would otherwise be entitled? My own view is that courts should be allowed to bar recovery on the grounds of such conduct only in limited circumstances. And here's the key passage: the basis of this power lies in the duty of the courts to preserve the integrity of the legal system, and is exercisable only where this concern is in issue. The concern is in issue where a damage award in a civil suit would in effect allow a person to profit from illegal or wrongful conduct, or would permit an evasion or rebate of a penalty prescribed in the criminal law. The idea common to all of these instances is that the law refuses to give by its right hand what it takes away by its left hand. And that applies as much to a counterfactual as to an actual claim. And then Lord Sumption explains, he goes on to quote, a more satisfactory explanation for these cases, I would venture, is that to allow recovery would be to allow recovery for what is illegal. It would put the courts in the position of saying conduct is both legal in the sense of being capable of rectification by the court, and illegal. It would, in short, introduce an inconsistency in the law. It's particularly important in this context that we bear in mind that the law must aspire to be a unified institution, the parts of which, contract, tort, criminal law, must be in essential harmony. For the courts to punish conduct with the one hand while rewarding it with the other would to create an intolerable fissure in the law's conceptually seamless web. And then he gets on to recite the conclusion. There needs to be in the law of tort, and I say that equally applicable in the field of compensation for cross undertakings, for a principle which permits judges to deny recovery to a plaintiff on the ground that to do so would undermine the integrity of the justice system. It's a limited one. Its use is justified where allowing the claim would introduce inconsistency into the fibre of the law. And then my lawyer go on to make the submissions, firstly, that this must apply equally to the enforcement of undertakings. There would be no coherence in a situation in which the court, by its order on the inquiry, compensated Fenris for a profit that it could only make by breaching another order of the court. It would quite literally be giving with its right hand the inquiry order what it had taken away with its left hand, the handover order. And I go on to point out that it doesn't assist Fenris here that the handover order was later set aside. Point being that for as long as that order was in place and a stay had been refused, there was an obligation to comply with it. So, my lord, that's the position in answer to my Lord Stephen's question. My lord, yes, from Lord Sales.
Can I just check what's happened in relation to interest or anything else in relation to the 150,000 euros? So I'm looking at paragraph 135 in the Court of Appeals judgment. As I understand it, the 550,000 euros is the profit that would have been made on the investment portfolio down to the 16th of February 2012. I think it is the trial outcome of the trial. Is that right?
Yes, I think it's the date of that handover order.
I'm sorry, to remind me, what was the date of the trial order?
Bear with me, and I'll just
put my notes away.
It's page 749. The trial took place between the 5th and 9th of December 2011, and that order was dated the 16th of February, which in Cayman means that's the day it was pronounced.
Right, so that the handover order following trial. Is that
yes,
right?
Exactly.
So, according to this finding by the Court of Appeal, Fenris would have had the 2.2 million odd plus this 550,000, which they would have made as at 2012. That's the end of this finding. Might it be said that the money has to be paid in to meet judgment? I appreciate your meet case where it's being said, no, the loss used throughout. I wonder whether it might be said that some element of loss continued after the judgment date in relation to that surplus 550,000.
Yes, I mean, it would be an element of granting loss on, it would be an element of leveraging the compensation. And one might wonder why there's ever an end point to the compensation. Imagine that the correct figure was, imagine that one assumes, as Mr. Lowe says, that the loss ends with the Privy Council. If the argument that Lord Sales is advancing as a potential argument is a good one, the investment loss continues forever because of the uplift on the investment. One can assume might continue to invest to generate profits in some way or form for a very long time in the future. But another answer to that is, in fact, the form of order that was made, that the order that I call the handover order. And if we return to page 749.
I'm so sorry, Mr. McMartin, before you move away.
Sorry.
I was looking to see whether there was any interest ordered in respect of that 550,000 from February 2012 down to down to the order made by the Court of Appeal.
I'm sorry, my lord, I misunderstood your question, and the answer is that there was an award of interest, yes. That can be seen, and that was the way that the whole of that money was dealt with. The page 138, sorry, page 230, paragraph 137. The court calculated the lost profit of 550. And in the second sentence, Justice Hooffield says, I think Fenris is entitled to interest on this sum pursuant to section 34 at the judicature rate, at the applicable rate of 2.25% per annum. For half the period from the 16th of February 2012 to the 18th of March 2019, the date of Justice Macmillan's judgment. I take this as the applicable period, bearing in mind that Fenris declined to run an alternative claim for a generic loss of profit, opting instead for an all or nothing claim premised on investment in small caps, following the strategy adopted by Mr Vigeland whilst he was with EFML. And then he quantifies that interest at €42,000. So yes, there was an award of interest on the entire amount, and it was cut off at the date of Justice Macmillan's judgment. And there's no complaint on the appeal about cutting off the interest at that date.
Yes, thank you.
My Lord, that's all I have to say about the duration of loss, unless there's any other specific point that I can help anyone with.
No, I don't think so. Thank you, Mr. McMaster. Well, we're back to you, Mr. Lowe, for your reply.
Yes, Mark, I'll be as short as I can be. The Court of Appeal rejected our claim that we had suffered loss of opportunity to invest, have a portfolio with some return, managed much in the same way as Ennismore. But what we actually pleaded, you saw, was an investment in European small caps. European small caps are defined in that pleading as being pretty much anything short of the very large companies and short of American shares or Russian shares or Chinese shares. But it's a very wide universe that we pleaded. We didn't plead a particular level of risk. We didn't plead anything, because what Mr. Vigeland did at Ennismore was, in terms of risk, pretty wide-ranging. He had sometimes leverage, sometimes not, and so on. And then we find that having rejected our case, our pleaded case, on a basis I don't quite follow, because they then find in paragraph 135 that that is exactly what we would have done. And it's not just faute demure. They have, having rejected the judge's finding of causation, they substitute their own, and we can see how they then come to it in paragraph 135. We didn't have a sort of a choice of things to put in. Once we knew that they had rejected, they were rejected the judge's findings of causation and were going to substitute their own. Not quite sure what they were thinking of. They then said they didn't really know. But what they find is the mechanism, exactly the same mechanism for loss that we postulated. And having then found that mechanism of loss, it was wholly inappropriate for them to alight on a particular form of calculation, in a very partisan way, just because Mr. McMaster proposed it, without going through all the other evidence. We don't have a transcript of what was said, but I did make to them the point that there was a whole load of evidence and that the judge had made findings. The only difference in the Court of Appeal's decision about quantum and, sorry, the compensation to be awarded and the judges, is that they substituted a different rate of return, one that very conservative rate of return that Ennismore suggested. And that is in the light of the judge having heard, and there were reams of statements about it, I've shown you those, huge amount of cross-examination. All of that was about the rate of return, the average rate of return that you should adopt. All of that, we say, was an exercise of quantification. None of it was challenged in the appeal. None of that exercise was challenged. So going to the point where they accept that the mechanism of loss, and that there would be some loss, is in not having a portfolio of some shares, they were duty-bound to accept the judge's findings because they hadn't been challenged. They could have been. I mean, you've seen how terse they are. Mr. McMaster, no doubt for reasons because he didn't want to get in all the evidence and have a trial about this in the Court of Appeal. That occupied far more of the inquiry. They chose, and I showed you why we made that submission in our Court of Appeal skeleton. It wasn't challenged. They chose not to quarrel with that quantum. They attack causation, and causation, as you know, is usually all or nothing. The Court of Appeal was not comfortable with this because Mr. Justice Macmillan's finding on causation was upset, largely due to no fault of our own, because he was so intemperate about the findings, and he said some things which were really wholly inappropriate. But that wasn't our fault. So they come to the point where, what do we do now? And they find causation. They have to deal with causation, and then they have to deal with quantum. I just wanted to pick up on one point my Lord Sales made to my learned friend about loss of a chance. There is an issue, of course, because you've seen from Parabola that you get to, when you're dealing with the loss of profit on a portfolio, that was a trading portfolio. And Hadji Georgia, you're dealing with the loss of opportunity to open a restaurant. Now, of course, you're dealing with all sorts of chances that affect a business and affect a restaurant, affect a trading portfolio. But what Parabola and Hadji Georgia do is say, when you evaluate those chances, that's an area of quantification. It's not loss of a chance. And I just wanted to show you Wellesley again, if I can, and this time in the Court of Appeal, because I mentioned it, but I didn't show you. It's at page 1958. And the relevant passage starts at 1986. Having dealt with, there's a discussion of Chaplin and Hicks, a case about personal injury, Mallet and Monagle. And then at the bottom he says, 97, as Mallet recognises, the assessment of damages may be determined on the court's view as to whether particular events would have occurred or will occur. Those chances are to be taken into account of in the assessment of damages. Questions of assessment of damage, however, have to be distinguished from questions of causation. These issues are discussed at length in the decision of Allied Maples, which I think I gave you the reference to, or I invited you to look at it. And then if you go to page 1991, 562 of the report, paragraph 110, having discussed some of the cases, including parabola, at 110, Lord Justice Floyd says it doesn't follow at all, however, that it's no longer relevant to consider the chances that WP would have obtained the mandates. The evaluation of that chance as part of the process of the quantification of damages. It would be wrong in principle to treat the conclusion on causation as if it meant that the chances of obtaining some part of the mandate were 100%. So what you have is you have a causation but-for analysis. Sometimes that involves loss of a chance. In the case of loss of the opportunity to use an asset, such as a tanker, or something, the right to compete in a beauty contest, Chaplain Hicks. What Mr. Justice Nugee suggested in the passages I showed you is that then you value that chance. But in the case of a trading asset, such as a restaurant or portfolio of shares, you don't look at that as a loss of a chance on the second stage of Allied Maples. You look at that as chances in the evaluation exercise. And that's what Wellesley meant. And so what the Court of Appeal, however, did was, if it went that far, it went into quantification, which wasn't appeal. It can't say at the stage of causation, or it can't really say it's a loss of a chance for you to invest in a portfolio, because that depends on your lordships remember the Rayleigh's case, Rayleigh solicitor's case. That depends on what I would have done, either plaintiff. So if you find either plaintiff would have invested in shares, then of course there are all sorts of chances as to whether I would succeed and all sorts of risks. And that's all part of evaluation and quantification. So what the Court of Appeal, where it went wrong, is recognizing it had thrown out the judge's findings on causation. It then substitutes its own, and those findings go much further than it was entitled to do, because it then goes into the rate of return, all of which we discussed. And in none of this is the Court of Appeal in a situation where it can say, oh, you didn't invest in capital European small stocks. You would have invested in small European small stocks without capital letters, because there was never that kind of technical division, as my Lady Rose asked a friend. So we say the Court of Appeal erred on that. In terms of the lost period, you have to remember that Mr. Justice Foster made.
Mr. Lord, I don't want to put you under time pressure. We're up to 2 o'clock, but I'm very happy to let you go on if you're going to be, say, 5 or 10 minutes.
Yes, I am, my Lord. No longer.
Yes, that's fine.
Okay. Mr. Justice Foster makes the order in 2009 at page 743, where you asked where Fenris kept its money. It had to keep, this is the clawback thing that was dealt with in the Privy Council. It had to keep a certain amount back within Ennismore's control for a certain period. And the dispute in the original proceedings was whether or not that clawback operated to prevent Fenris taking out its money. Fenris redeems some of that money because it's held in shares in a Cayman fund. And in the counterfactual world where there's no order, Fenris is able to take that money, and it has no account in Cayman, and there's no reason for that money to come out. It was, I think, the redemptions were paid out in March or April, thereabouts. So in the world where, and that's why you have Mr. Justice Foster then making the order at page 743 and 744, you see he orders money to be paid into this bank account. He could only do that because the money was in Cayman and he makes that order. In the counterfactual world, that order would not have been made. So the money is elsewhere. The judgment.
But in the counterfactual world that you were putting forward, where the money is invested in European small caps, either with or without capital letters, you're assuming that the money then would not have been in the Cayman, even though the money that he invested on behalf of clients before seems to have been in Cayman.
No, lady, he
got the facts wrong.
I think that's wrong. The money he invested, he managed. He was a manager. He wasn't a custodian. The money he invested, he managed from Norway. There was no dispute at the trial about that. He had more connections with London than Cayman. He had no connection with Cayman. Fenris itself was a Belizean company. So why would he have left that money in Cayman where he had no bank account? And he was no longer dealing with Ennismore. He'd been effectively, they parted ways. He wasn't going to put his money in Ennismore funds. And that wasn't the case he put, and then no one who suggested he would have done. So he would have put the money, he would have invested it. He's one of these people who could probably work remotely from anywhere. But he lived in Norway, and the logical place to have custodians is in London. I mean, you don't have, this isn't, not many people live here. You know, it's not something where you unless you're trying to do this for tax efficient reasons, you're not going to have a vehicle here. Anyway, he was a Norwegian, so he couldn't have done that. But in 2012, when he gives his judgment, he can't, in that counterfactual world, make the order that Mr. McMaster says, because there's no money in Cayman. So the real issue, and the issue of that my Lord Stevens put to me, learned friend, is about discretion, is about what Fenris could have done at that time. Now, if you're the subject of a judgment and there's an appeal, and you go to the Court of Appeal and say, look, don't make me sell my house pending the appeal. You know, I'll make sure that I'll give you some sort of charge over it if I really have to. The Court of Appeal rarely does that. If you're a defendant with a trading business, the Court of Appeal is not going to say, I'm sorry, you're going to have to close that down, appoint receivers, sell it for whatever you can, pending the appeal. And if you had and Fenris was a trading business. If it on this counterfactual world, it would have been trading. So why couldn't it have gone to the Court of Appeal at that stage and said, you know, just let things, keep the status quo, maybe impose some protection, but for no, you know, for God's sake, don't make me liquidate my portfolio, which is trading counterfactually profitably. And the Court of Appeal in those circumstances would have been a very different situation where if you have cash, which is already paid over to the other side, to get a stay of that order is a very different order, because you're going to have to persuade the Court of Appeal that the plaintiff isn't good for the money, you know, that you're going to suffer real prejudice. And sometimes the defendant can say, well, stifle my appeal and so on, but it's a very different application. And given that the prima facie rule is that you prima facie we've suffered loss, see SCF tankers, that ought to have been enough to get us over that part of the hypothetical inquiry. And we wouldn't have been doing anything wrong by doing that. And I accept, of course, inquiries are discretionary. They're discretionary when you order them. They should be principled when you make a payment out. I also accept that perhaps it's an equitable jurisdiction. So if we came with bad, you know, unclean hands or something, that can't be assumed in the counterfactual scenario. Can't be assumed that we would disobey orders. But why couldn't we have said to the Court of Appeal, look, we're doing really well. Don't make us liquidate this. You've got a Credit Suisse of the custodians and so on. So those are my submissions, unless there's anything else I can help you with, my Lord Lady.
I don't think so. Thank you very much, Mr. Lowe. We are most grateful to both counsel and, of course, their supporting teams for the written and oral submissions which we've heard. And the board will now take time to consider what advice to tender to Her Majesty. Thank you very much. The board is adjourned.